When does a GAL get appointed?
I always tell my clients that when parents are not able to.
Is there any protocol that they have to follow to demonstrate they actually have tried to reach an agreement?
Most cases, you are required to initially.
All right. Hello, and thank you for joining us. I have with me today attorney Bailey Holt. Bailey is a senior associate at Sterling Law Offices, and we are lucky to have her today as she is quite an expert on the topic of conversation. Bailey, how are you doing today?
I'm good. Thanks for having me on again.
Yeah, thank you. Today, we are going to be talking about guardian ad litems and social workers in family court cases. So, when custody or placement is contested between parents, it seems like suddenly there's a whole lot more people in the courtroom that are involved in the case aside from just the lawyers and the parents. So, guardian ad litem, sometimes we refer to those just with the acronym of GAL, and social workers, they get involved, and it can be a little confusing to our clients about how they're different, what are they working on, and what's going to be happening, how do they influence my case. So it's important for our clients to know how they're different and how they influence the case. So I feel like I've seen clients confuse, right? Like the difference between a guardian ad litem and a social worker. So what is the difference?
Yeah, so guardian ad litems and social workers, they're not both on every single case that we might have. It's very case specific on whether or not you end up having both or just one or the other. Their typical process, there are some similarities with the process, such as they're both conducting some sort of investigation. They're interviewing children, parents, people that have frequent interaction with the kids, teachers, doctors. So they're also looking at school reports, medical reports, and both of them have the role of making recommendations to the court based on their findings in these investigations. So they're there participating in court hearings as part of their role.
So it sounds like they have similarities, right? Like their investigations, their who they might be talking to, they're interacting with the parties, showing up in court. How are they different?
So they have different roles in court. A guardian ad litem, their main role, they're appointed to advocate for the children or for the child's best interests. Their role is to take a position in court on what they believe that custody and placement arrangement should be for the child. Whereas the social worker is someone who does a more thorough investigation and they prepare a formal report to the court, and they actually serve as a witness in court. So when you're actually in court, a guardian ad litem's more there as an advocate, advocating for the best interest of the kids. They can call witnesses, they can object to certain witnesses, or they can object during testimony. Whereas a social worker is an expert witness, and they can be on the stand, and attorneys, including guardian ad litems, can question the social workers on their findings and their observations.
Got it. Yeah, I mean, it sounds like that's an important distinction, right? Between another attorney advocate on the case versus an actual witness that's providing evidence to the judge or the commissioner conducting the hearing.
Yeah, absolutely. And they could have the same findings. And it's also possible in a case where they have very different findings where they could disagree. They work together on a lot of different issues. And a lot of the time they do agree, but they're not required. Guardian ad litems aren't required to agree with the findings of the social worker. And a social worker is not required to agree with a recommendation or a position that a guardian ad litem might be taking.
Very interesting. All right, well, let's start with some GAL questions specifically. So we're talking the attorney role, guardian ad litem. When does a GAL get appointed?
If there's a dispute on custody placement. When parties agree, almost never would a guardian ad litem be appointed in that type of situation. They only intervene when parents are not able to make a decision. I always tell my clients that if you can reach an agreement with the other parent on custody and placement, that's always best. You know you and your kids and your situation best. And when you're turning to a guardian ad litem and you're not able to agree, you're bringing in a third party to help make decisions for you and your family.
And the court sort of makes parents at least try
Mhm.
to reach an agreement, right? I mean, is there any protocol that they have to follow to demonstrate they actually have tried to reach an agreement?
Most of the time, parents are required to participate in mediation through their county to try and resolve custody and placement. There are limited reasons why mediation might not be appropriate if there's some sort of like domestic violence issue, if there's some major safety concern that needs to be addressed quicker. But most cases, you are required to initially participate in court ordered mediation. And then if mediation fails, meaning you sit down together with a third party neutral and you're still not able to come to agreements on your own, then the guardian ad litem would be appointed. But most of the time, they aren't just going to let you bypass that.
Got it. And so if you go to mediation, you reach an agreement. Maybe you didn't think that was possible, but lo and behold, you reach an agreement. You can avoid that guardian ad litem being appointed on your case.
Yep, you just tell the court in writing what your agreement is. It's marital, put it in the form of some sort of marital settlement agreement. Both parties would sign it and it gets filed with the court, and there's no guardian ad litem needed.
Got it. And then who appoints a guardian ad litem if it comes to that? Mediation fails and we still don't have an agreement, then what?
It's appointed by the judge. So either party can petition for the appointment of a guardian ad litem to the judge. Typically, in your petition, you have to put in there that you've tried mediation and that mediation has failed, and then you would request a guardian ad litem be appointed. It is possible that you can request a certain guardian ad litem if the other attorney agrees, but a lot of the times the court just picks one. Then you're not having any sort of biases on who the guardian ad litem is. It's not favorable to one party or the other unless the two attorneys both agree on someone that they feel like would be good in their particular case. Maybe they would agree on a guardian ad litem and use that one in their case.
And can any attorney be a guardian ad litem? Can the judge just choose literally any attorney out there?
No, there's requirements in training that guardian ad litems are required to have. You have to have a certain amount of guardian ad litem training hours, and you have to be in good standing in Wisconsin. And typically, most counties have a list of guardian ad litems that are available for appointment, and they kind of go down the list and see who's who's able to take cases and who's currently taking cases.
Got it. And, like what are they looking for in doing their investigation so that they can ultimately make a good recommendation to the court?
Mm-hmm. Guardian ad litems are going through the entire statute. They're looking at what's in the best, it's called the best interest factors, what's in the best interest of the kids. Some of those would be age of the kids, like the work schedules of both parents, the wishes of the kids, the history, mental health concerns, drug or alcohol use. There's more factors than just that, but the guardian ad litem will go through each of those factors and determine some of them might weigh heavier than others depending on the situation, and they'll ultimately make a decision after evaluating each of those factors in the statute.
Got it. Okay, and now let's switch gears a little bit to discuss social workers. So you had said earlier, guardian ad litem is an attorney advocate for the child's best interests, whereas the social worker is appointed as an expert essentially to provide testimony to the court, providing evidence as far as what's in the best interest of the children.
Yeah.
So are social workers appointed at the same time as a guardian ad litem? Are they involved in all cases? How does that work?
Not typically at the same time. I would say most commonly you see a guardian ad litem. The court's required to appoint a guardian ad litem. If there's a dispute, it says the court shall appoint a guardian ad litem. So typically you start there. And then social worker involvement would be a case by case basis. Sometimes it depends on the county you're in, how involved the social workers are, or when they get involved. For example, in Waukesha County, the social workers are on staff in the courthouse and they're often involved when a guardian ad litem is appointed. Whereas, like Milwaukee County, for example, they don't have social workers that work specifically in the courthouse through the county. So it would be a private social worker that you're hiring to become involved. But generally speaking, social workers get involved if there are specific concerns in a case, maybe substance abuse, domestic violence, mental health. Also, if you see a case that's going to be heading towards trial, meaning where even if a guardian ad litem is involved, even after them making recommendations, there's no agreement, it's clear this case is heading for trial, you're going to need some sort of expert witness, then you likely would want to get a social worker involved so you have someone that is able to testify at a trial.
Yeah, that makes sense. Okay. And then who pays for these individuals, whether it be a guardian ad litem or a social worker? I'm assuming there's a cost. So who pays for that?
Yeah, it's typically split equally between both parties. both the cost of the guardian ad litem and the social worker. But you're absolutely right. It can be very expensive, especially if your case goes on for a long time and several months. But both of these guardian ad litems and social workers are extremely important. They have a huge impact on the outcome of your case and ultimately custody and placement. So it's really important throughout the process to be involved, to be responsive with them, because they're making decisions and notes to the court on what's going to be happening with your children.
Yeah, and what's more important than that, right? I mean, most of our clients would tell us in the very first consultation that the most important thing in the case, the most important issue that they are concerned about is their children and the time that they get with their children and what is that going to look like. So, what I heard you say is stay involved, communicate, and be receptive to this process because they have a huge impact on the outcome of what your parenting time is going to look like when this is all said and done.
Yeah, absolutely.
Well, great. This is very helpful. So, I mean, the takeaway for us today is guardian ad litems and social workers, they serve pretty different roles. I mean, they may look similar and people may get them confused, but they have important differences. But ultimately, they both have a major impact on what the future of custody and placement with your children may look like if they are involved in your case. So, you should take it seriously.
Yeah.
Very good. Well, thank you so much, Bailey, for being with us today. We appreciate you as always.
Thank you for having me.
Guardian ad litems and social workers can make or break your custody case. So why do most parents accidentally sabotage their chances during the actual decision process? The mistakes happen when Wisconsin courts are weighing these specific factors, and most parents have no idea they're even being evaluated. See exactly what judges are looking for in our next video.